Can the International Court of Justice stop the war in Gaza? The UN's top court will hear South Africa's genocide case against Israel on January 11th. The initial hearing will likely focus on South Africa arguing for an interim order, asking Israel to immediately suspend its military operations in and against Gaza. We asked 3 legal experts about the arguments and what to expect in the coming weeks.
Their main argument is that Israel is committing genocide and is also failing to prevent genocide and also to prevent incitement to genocide. And so that is based on Article 9 of the Genocide Convention, which gives jurisdiction to the International Court of Justice. In its 84-page long application, South Africa has provided details as to why Israel's actions and omissions are genocidal in character, because they're intended to bring about the destruction of substantial part of the Palestinian national, racial, and ethnical group that is living in the Gaza Strip.
Israel has rejected these allegations and called the South African case a despicable and contemptuous exploitation of the ICJ. It also accused South Africa of giving political and legal cover to the October 7 terror attacks by Hamas.
לא דרום אפריקה, זה לא אנחנו שבאנו לבצע רצח עם, זה החמאס, הוא היה רוצח את כולנו.
Israel claims it's doing everything it can to avoid harming civilians, while Hamas uses them as human shields.
So this is not like a criminal case where it's required proof beyond a reasonable doubt. This is more like a higher risk probability of genocide being committed or impending. And South Africa has detailed the wrongful conduct by Israeli authorities and the genocidal intent.
They have drawn from UN and other expert reports as well in talking about the risk or the occurrence of genocide. They have looked at the extensive destruction of Gaza. They have looked at the extensive killing of Palestinians that has taken place, including predominantly civilians, including, as we know, many children that have been killed.
And the genocidal intent can be inferred both through the pattern of conduct of Israeli authorities, the actions of the IDF in the Gaza Strip, but also through statements that have been issued by senior Israeli officials. And South Africa has provided a long list with examples of such inflammatory and dehumanizing statements, including by the Israeli Prime Minister, the President, Minister of Defense.
And some of these statements are open to interpretations that are consistent with genocidal intent. It still, however, will be, I think, difficult for South Africa to prove that these statements were actually translated into policy, especially since there have been also many other statements by many officials, including some of the same officials which I have mentioned, the highest leadership of government and the IDF, that actually strongly rejected the insinuation that Israel is targeting, for instance, Palestinian civilians, and have been maintained that Israel is conducting its war campaign within the confines of international law.
First, there is a distinction in what the ICJ and the ICC do. The ICJ deals with state responsibility, as I said. The ICC deals with individual criminal responsibility. Their procedures are also separate.
The ICC is already looking at a host of allegations relating to the Israeli-Palestinian conflict, in fact, going back all the way to 2014. The ICC prosecutor has already been to Israel and to the Palestinian territories, and he and his team are looking into that. I believe that for South Africa, there was an interest to, in a way, expedite the process. Only the question of provisional measures would be discussed. The court would have to ascertain, that it does have on its face jurisdiction to hear the case, that the claims made by South Africa are plausible.
This is not the merits phase. The merits, which is where the court, if it gets that far, would decide on whether or not Israel has breached its obligations under the Genocide Convention. So This case is not there yet. And so the provisional measures that they have requested are essentially around the idea of Israel suspending military operations in and against Gaza.
The facts on the ground and the statements by senior Israeli officials are damning enough for this stage of the proceedings. And most likely the court will indicate the provisional measures along the lines requested by South Africa.
So if a provisional measures order is issued from the ICJ, then all of the other state parties to the Genocide Convention should be, as part of their obligations under that convention, pressuring Israel to comply with that provisional measures order.
In some cases, the court simply reiterated the legal obligations of the parties, namely reminded the parties of their obligation not to commit genocide. Since Israel is maintaining that it is not practicing genocide, it would be relatively straightforward for Israel to comply with a measure if it is formulated in that sense. But we have seen in another genocide case in Ukraine versus Russia, that was adjudicated last year, where the court had ordered Russia to stop the war in Ukraine. And there we have seen Russia effectively refuse to comply with those provisional measures. So if the court would order Israel, for instance, to stop its military campaign in Gaza, I would imagine that we will see a reaction that is probably closer to the reaction that we have seen from Russia in that regard.